Right then, officers, welcome to this highly focused explainer on mens rea. I know you already know the realities of policing out on the streets, but the exam hall, well, that demands a totally different level of precision. To get those critical points on your upcoming sergeant's exam, we're going to break down the exact legal frameworks, the definitive case law, and of course, those classic traps the College of Policing absolutely loves to set regarding a suspect's criminal state of mind.
Here is your briefing syllabus for today. We'll be covering the foresight intent ladder, specific versus basic intent, the intoxication decision tree, subjective recklessness, and finally, transferred mens rea.
Section 1. The foresight intent ladder. Elevating to intent. So to kick off this first core framework, this ladder maps out exactly how a jury climbs from a low probability event right up to the point where they can legally infer intent. Now, you know as well as I do that foreseeing an outcome and actually intending it are not the same thing. Confusing those two, that is a guaranteed dropped mark on your exam. You start right at the bottom, a low probability of a consequence occurring. As that probability increases, well, it becomes much more likely that the defendant actually foresaw it happening. But listen, foresight itself is just evidence. It's only when you reach the very top of this ladder that a jury may legally infer that the defendant truly intended the consequence. And right at the top of that ladder is the definitive virtual certainty test. This comes from the landmark Woolen case, which is an absolute staple of the promotion syllabus. Back in 1999, the defendant threw his 3-month-old baby onto a hard surface in a fit of rage, which tragically resulted in the child's death. The crucial legal takeaway for you here is that if death or serious bodily harm was virtually certain, and the defendant actually appreciated that fact, the jury may infer intent. Now, it doesn't mean they must, but they are legally permitted to. So do yourself a favor and lock the name Woolen and the phrase virtual certainty together in your mind right now. Section 2. Specific versus basic intent. Categorizing the charge. Okay, you absolutely must be able to differentiate specific intent, where a particular consequence is required, against basic intent, which simply requires bringing about the circumstances. Specific intent crimes, so things like murder, theft, or Section 91A burglary, they require the prosecution to prove the suspect intended a very specific outcome. Basic intent crimes, on the other hand, like manslaughter, Section 20 GBH, or Section 47 ABH, well, they only require that the defendant intended to bring about the circumstances or was simply reckless as to whether they would occur. Understanding this division is absolutely non-negotiable for the exam. All right, time for a classic exam trap. Just pause for a second, read the question on the screen, and lock in your answer in your head before we look at the legal precedent. Let's say you have a suspect who is completely hammered on a Friday night and they commit a basic intent crime like a Section 20 GBH. Does their voluntary intoxication give them a defense just because they couldn't form the mens rea?
Section 3. The Intoxication Decision Tree, Navigating Drink and Drugs.
To get that last question right, you've really got to know this grid. Seriously, this is your ultimate mental map for the exam hall. This right here is where cases are won and lost, both in court and on your sergeant's paper. Notice how voluntary intoxication only offers a potential defense for specific intent, whereas involuntary intoxication covers both. Think about it. If someone voluntarily gets drunk, it might negate the mens rea for a specific intent crime like murder, potentially dropping the charge down to basic intent manslaughter. But if the intoxication is involuntary, say their drink was secretly spiked, well, that provides a full defense to both specific and basic intent crimes, assuming no mens rea was formed at all.
So the answer to our earlier exam trap? It's a resounding no. This was established definitively in Majewski, which basically means getting voluntarily intoxicated acts as recklessness in itself. The House of Lords ruled back in 1977 that if a suspect chooses to consume drink or drugs, that choice is inherently reckless. Therefore, for basic intent crimes like Section 20 GBH or Section 47 ABH, they cannot use their drunken state as a shield. The voluntary intoxication actually supplies the recklessness needed for the conviction.
And here is another strict rule the examiners absolutely love to test. If the suspect formed the intent, even with lowered inhibitions for so-called Dutch courage, they are still guilty. In the Kingston case, the suspect's drink was spiked, so involuntary intoxication, but the court ruled that because his lowered inhibitions still allowed him to form the genuine intent to commit an indecent assault, he was guilty. A drunken intent is still an intent. And as we saw established in Gallagher, if you decide to kill someone and then you down a bottle of whiskey to get the Dutch courage to actually carry it out, your intoxication offers absolutely zero defense.
Section 4. Subjective recklessness explained. the RVG standard. Now, take a look at the stark contrast here between the old, outdated objective test and the modern requirement to prove what the actual defendant realized. This marks a monumental shift in English legal history, and you are guaranteed to be tested on it. It used to be all about the reasonable person. The court would essentially ask, would a reasonable, sober person have seen the risk? But the law evolved. Now we use the subjective test. The question is entirely internal to the suspect. Did this specific defendant, with their specific age and mental capacity, actually appreciate the risk they were taking? And was it unreasonable for them to take it?
This new standard was properly cemented by the RVG case in 2003. You had two boys, aged 11 and 12, who lit some newspapers under a wheelie bin behind a co-op. The fire spread and caused about £1 million in damage. Now, an adult would have easily foreseen the risk, but because these specific children genuinely did not appreciate the risk of the fire spreading, their convictions were quashed. Recklessness strictly requires subjective awareness.
Let's test your knowledge on some old legal terminology with another exam trap that regularly catches out even highly experienced officers. When the Offenses Against the Person Act 1861 talks about someone acting maliciously, like in a malicious wounding, does that actually mean they acted with hatred, ill will, or spite?
The examiner is definitely going to try and trick you on this one. But as we see here, malice just means intention or foresight of some harm, completely regardless of any actual ill will. Let's say a suspect throws a coin at a victim, only foreseeing that it might cause a tiny scratch, but it actually hits the victim in the eye and causes grievous bodily harm. They are guilty of Section 20 GBH. Why? Because they had foresight of some physical harm. The extent of the actual harm doesn't need to be foreseen at all.
Section 5. Transferred mens rea rules, shifting liability. Let's track the sequence of transferred mens rea, where intent simply jumps from the intended target straight over to an unlucky bystander. It's a brilliant legal mechanism that ensures criminals don't just escape justice because they happen to have terrible aim. Look at the timeline. Steve intends to punch John, so he has the mens rea for assault. He physically swings, meaning he has the actus reus. He misses John completely and hits Phil instead. The law simply takes the mens rea intended for John and transfers it directly onto Phil. Steve is fully liable for the assault on Phil. But beware the trap. Transferred mens rea completely falls apart if the nature of the offense changes. Like if you miss a punch and break a window instead, that cannot transfer to criminal damage. The 1874 case of Pembleton perfectly sets this rule. If you throw a stone intending to hit a person but you miss and smash a shop window, your intent to commit assault cannot legally transfer into an intent to commit criminal damage. The crimes are fundamentally different. Transferred mens rea only ever works when you are transferring intent for the exact same type of crime. Section 6. Acing your sergeant's exam, final review. Okay, let's consolidate this before you hit the books. Here are the 4 foundational case law principles you absolutely must take away from this explainer. Repetition builds retention, and you need these available on an instant recall. First, Woolen. If the outcome is a virtual certainty, the jury may infer intent. Second, Majeski. Voluntary intoxication is recklessness in itself, and it offers zero defense for basic intent crimes. Third, RVG. Recklessness is always tested subjectively against what the actual defendant appreciated. And finally, transferred mens rea only applies when the intended crime and the committed crime are exactly the same. I'm going to leave you with this final, provocative exam scenario to test if you've truly mastered the interplay between intoxication, basic intent, and the rules of self-defense. A suspect gets voluntarily drunk, mistakenly thinks they are under attack, strikes out, and kills someone. Do they have a defense? Well, as established in the O'Grady case of 1987, a drunken, mistaken belief cannot be relied upon for self-defense in murder or manslaughter. The law remains completely steadfast. You cannot hide behind the bottle when you've taken a life. Keep these legal precedents sharp, apply them relentlessly, and go get those strapes. Good luck, officers.